Thanks everyone for joining in. In today's webinar, we'll be talking about health apps and specifically about the enforcement done by FTC, the fines, the health breach disclosure and notifications which are happening. Again, welcome everyone. I am Vaibhav. I'm the founder and CEO at Privado. I'll be your host for today. And with me are my co-panelists and experts, Kate Black and Debra J. Farber. Would be great to get an introduction from both of you, Kate and Debra.
Sure, I can go ahead and get started. My name is Kate Black. I'm a lawyer focusing on health privacy and data use issues. I've worked on all sides of the industry, first for a nonprofit, then the Department of Health and Human Services. I worked in-house at 23andMe and now work at Hintze Law, which is a small boutique privacy and data security law firm.
Hi, I'm Debra J. Farber. I am an 18-year privacy operations veteran, of this space, and I currently have shifted left. Instead of doing, what I was doing, which is more operational focused, consulting, analyst style work. I am now working a lot more in privacy tech, where I'm an advisor to several privacy tech companies, including Privado. And I'm also the host of the Shifting Privacy Left podcast, aimed at privacy engineers. During my 18-year experience here, I cut my teeth on HIPAA as a chief privacy officer back in 2010 for the advisory board company, which was a public healthcare company. And so I'm definitely familiar with the healthcare world, and it's wonderful to be here today to kind of talk about these issues.
Yeah, no, thanks for joining in. I'm really looking forward to our conversation today, especially kind of the breadth both of you bring to the table, not just from the law perspective, kind of interpretation of the law, and actually kind of going back from an operational perspective, how these data flows and the lineages problem, and what we end up seeing, right, when the products are built and when marketing teams are doing their work, right? So super excited about that. Quickly summarizing what all we'll discuss today. So we'll first start and go into kind of in the background of why we are seeing so much enforcement on the health side, specifically on the health apps. We'll also look at the recent fines and see what was the reason of these fines. And I think with these fines, the definition of the health data has been broadened a lot. So we'll definitely spend some time in discussing what is health data, what it could mean from your app perspective. We'll also look at the third-party ecosystem in mobile apps, and that's kind of important because that's one part is the health data. The second part is where your data could end up being. So a quick list when you're talking to your product manager or app developer. And finally, when you go back, how can you comply, right? How can you prevent such incidents from happening, and how can you make your company better from a privacy perspective? Starting in, right? So we all kind of lived through the pandemic, and everything was shut, so everything went online, and so did health, right? So there were so many telehealth apps, digital health adoption went through the roof, and we kind of were looking at CB insights, and the statistics were. Even I was surprised. There were 1,300 health and biotech startups founded since 2020, over $80 billion, right? Which means, obviously all of us went online and took the main services from a health perspective on these applications. And while there was, I'm sure, amazing growth, we trusted these applications or these health app companies with our data. I really want to kind of dig deep on, while there was so much growth which was happening from a privacy perspective, Kate and Debra, would love your opinion on where was the gap when these companies were thinking? Because in my mind, if I'm a health tech company, I would be thinking about privacy earlier, maybe because there is HIPAA or so what's kind of the gap from a perspective of these health app companies thinking about privacy?
I think there were several challenges here. One is that companies might have looked and seen like what does it mean to be part of health privacy, and maybe found HIPAA and said, oh, that doesn't apply to us because HIPAA applies to companies that are you're collecting personal health information or protected health information that's used for the payment, treatment, and operations of healthcare. So if you're not delivering healthcare or healthcare billing or any of the traditional ways of doing healthcare, you're like, oh, okay, I'm just a regular startup then, right? HIPAA doesn't apply, and you might not know to ask to seek further guidance that there might be something else like the FTC breach notification rule that does apply. And so I think there's partly that, partly the fact that we desperately needed telehealth services, and that scaled so quickly. So all of a sudden, companies needed to be, the healthcare companies needed to be online so quickly. And then given that everybody was concerned about COVID, all of the, this quantified self kind of, I want to track my own health and see if there's any potential, I don't know, deviations from that might signify that I might, have COVID or something else. Through COVID tracing apps, through all of these different apps around healthcare, just bursted onto the scene. And I, rather than it being in some sort of ordered way we can learn from others, it was just kind of like running with scissors. And I think, I'd love to hear Kate's perspective on this, but I think a lot of the challenge was that, people went to market so fast, there wasn't enough time to really analyze how was data being, not just being protected of the user, but maybe an over focus on compliance, where they didn't think they had to seek additional knowledge, I guess, to make the app safe for health. And then of course we'll get to that, but like Roe v. Wade kind of, threw everyone through a loop when it was overturned by the Supreme Court. And we can get to that as well. But I think that's part of the concern for this explosion of apps really happened around where they were collecting a lot of this location data that can then be, potentially a company could be doing, really have thought well about protecting personal health data, but a subpoena from the government of a state that doesn't allow abortion might, cut through all of that privacy, right? And all of a sudden now under state law, you have to give that data if you collect it to the government, which could be used to prosecute women seeking abortions. So all of a sudden things got serious. And I think this administration really wanted to, address that quickly. Anyway, we were only on question number one. So
yeah, I would just add to some of those wonderful insights that tech companies at the end of the day need customers to pay for their services, and digital health tech companies are no different. They've oftentimes hired and implemented the same marketing practices and the same customer acquisition practices that any other tech company would. So they use the same tracking technology, targeted advertising, and because especially during the pandemic, it became such a noisy and competitive landscape, I think they took that marketing and data use strategy to the extreme. And in doing so, I think created a lot of practices that frankly, the average user probably A, wasn't super aware of, and B, may not have been comfortable because there is such an opaque and unclear landscape of data transfer in the advertising marketing space. I think on top of that, there's also just been some distrust growing in the public about these large advertising platforms, how Facebook uses your data or how Google uses your data has had a lot of media coverage and a lot of concerning reports, especially around the use of sensitive data.
No, that makes complete sense. And kind of when we were kind of putting up this slide, I was trying to. There were so many events or so many things that happened over the last 10 months from an enforcement perspective. It was super difficult to put it in one slide. But yeah, would love to get your opinion, Kate and Debra, about how it kind of started. I know, Debra, you talked about Roe v. Wade, and that's kind of our starting point in this slide as well. But after that, what have been the key guidance from FTC, and we know there was a markup investigation as well. So yeah, just wanted to get your perspective on starting from Roe versus Wade, what has happened so far, and what's the guidance which is coming from FTC and the likes.
Okay, well, how about I take the July 2022, and then I will let Kate kind of take the others. I'll set it up and let her kind of speak to the specifics. But after Roe v. Wade was overturned, and there was this great concern about current health apps potentially having, great risks to women, especially in states where, like they could subpoena data. The FTC wanted to, they came out with guidance on, hey, just because it might not be covered by HIPAA, your health app very well might be covered by the FTC breach notification rule, and then gave guidance on what this means. And you could even, for a real in-depth unpacking of this, V and I had done a webinar, a few months after the guidance came out, called the FTC Crackdown on Data Flows, What It Means and How to Comply. And I urge you to go take a look at that for, definitely more in-depth unpacking of it. But essentially, HIPAA only applies to companies, as I mentioned before, that, covered entities, which are organizations that are collecting protected health information as defined under HIPAA for the purposes of payment, treatment, and operations of healthcare, and their business associates, so their partners, their vendors, whoever they're sharing data with. Where that doesn't apply is for companies that are maybe collecting data on behalf of you, you want to collect that data. It's in your phone, it's in, on your servers that you own, but that you might not know that this data is being shared with other third parties if the app's not telling you, right? And this is kind of where the guidance is, to be really careful about location data. Do you even need to collect it at all? Because if you don't have it, you can't provide it to a government, right? Or you can't provide it, it can't get breached if you don't have it. Or, data minimization basically is kind of the point. Is like, think about whether or not you really need sensitive data in your app, and how you're going to protect it. But also, you can't share that, or you shouldn't share that, or you should protect it as sensitive data. And if there is a breach, or a breach of that, user's trust, you could be prosecuted, not prosecuted, you could be seeing some fines and, from the FTC. Now, the challenge is, even though this rule has been around since 2009, the FTC's breach notification rule, HIPAA has been around since 2003. There has never been an incident of enforcement until recently for the FTC breach notification rule. And that's why this is so, fascinating as to what's been going on lately. And so in 2022, the FTC said, hey, look, we've never actually enforced this. In fact, we've only seen 2 companies even tell us that they've had a breach, that were non-HIPAA covered entities. And so, is this rule even helpful? What should we add to it? Is there anything we need to remove? Is this aligned with what industry needs today? And I will now pass it over to Kate to tell us about what's happened since then.
Yeah, I think that's right. That the FTC and HHS both began signaling that they were going to step up and focus on health technology through that announcement and through some other policies initiatives. I think that, coupled, as we discussed, with the pandemic and some public discourse and cultural shifts, really culminated, or I guess kicked off, what I think will be a continuing enforcement directive on health technology products and services. In October, it was reported that there was a data breach out of Aurora. Then in December, HHS guidance was released that was really, I think very shocking to a lot of people, somewhat predictable based on some of the other guidance and information that HHS had teased in the previous years, but not necessarily came out right and said. And then finally, with the BetterHelp and GoodRx fines, I think both of those were really used by the FTC to announce their continued focus on the use of sensitive data. Really, as you mentioned, with the understanding that this would help lay out their understanding of what kind of data needed to be included in certain notices, when and if consent was needed to process and share. Something of a mess of documents, meaning that the FTC wasn't particularly clear in establishing what that framework was. And I think they may have done that on purpose to give themselves the latitude to make really fact-based assessments so that they could review a product or service in the future and determine whether and how there were any sort of consumer harms or lack of adequate consumer protection.
Yeah, no, thanks for that. I mean, what I could see is, like, on one hand, there's this inclusion of health tech startups, and then there is this, huge enforcement directive now for multiple reasons, as Kate and Debra, you pointed, right? Which gives us in a situation now that, none of these, as you said, health tech startups or health tech companies, even scaled up companies, are like any other company. They have to provide service and make sure that users are happy and then charge for it, right? And this becomes, I would say, an important pillar as they're building their company, right? But yeah, kind of going deep into the recent fines or even the breach disclosure, I would love to get what I could see on the screen is like there were at least 2 or 3 flavors. One was what was there in the application itself. So there was a mobile app which had either a tracker or there was a data sharing which was happening. There was definitely one on the disclosure side. So there was a privacy policy with some seals or some promises which were not really true. And then obviously there were some marketing activities which were happening separately on a different platform like Facebook and Google, where you could do something or target people. So would love your opinion on all these flavors in terms of what were the reason of these fines and what we can learn from them.
Yeah, I think it's important to set out from the get-go that neither HHS or the FTC said that marketing practices in digital health were illegal. And so I want to make clear that this is not a revolution in the industry, meaning that everyone has to remove tracking technology or digital marketing initiatives. What I think both have said is that, hold on, wait a second, let's apply a regulatory mechanism to them so that it's not just, the quote Wild West of data use. And that, hold on, this data is actually health data, either subject to HIPAA or FTC enforcement, and we will take seriously our oversight of that. And so I think front and center to that enforcement is the requirement that all of these practices that you have listed have to be included in notices to the consumer, both in a notice of privacy practices as well as in your general kind of privacy policy or privacy statement that you have on your website. And what's really important that you do in those documents is lay out how you utilize digital marketing and ad tech. Make it clear that the data could include health data, could include sensitive data, and that the combination of data usages and data processing activities will likely be shared with all these third parties. I think it gets a little confusing and may cause some mental gymnastics to try to think about this enforcement vis-a-vis some of the state laws. Because when you think about the use of Facebook for lookalike audiences, and whether or not that would be considered a service provider relationship under the CPRA, things start to get really sticky. And so your privacy notice is going to take perhaps a lot more work and language tweaking than you as a startup probably want to invest in, but highly recommend you spend that time and get it right. With really focusing on 3, I think, key areas. The first is the use of trackers for technology, or the use of tracking technology for retargeting, as you said. So if I've clicked on, a mental health service and I leave the website or abandon my sign-up flow, you may get retargeted, and that data collected by whatever retargeting platform is likely going to be considered sensitive health data because it includes data about my mental health. The FTC didn't seem to care that I could be interested in mental health services or searching for mental health services or clicking into products about services related to healthcare that weren't related to my own health. I think there's oftentimes an argument in the industry that I could search any number of websites or Google COVID. That doesn't mean I have COVID. It doesn't mean that I'm interested or have a mental health diagnosis. But the FTC really looked at this from a lens of, could that data be used against you to harm you? Could a potential employer or product or service discriminate against you because they could assume or infer that you had that sort of health condition or history? And if the answer is yes, that there is a discriminatory potential, then that's where the consumer protection arm steps in and says, no, let's put some guardrails around that. The second, as you have here, would be custom audiences and lookalike audiences. Interesting here that the FTC basically said that even if you don't actively share health or sensitive data, if you use sensitive or health data to inform or curate a list of individuals for a custom audience or a lookalike audience, that is going to be considered a disclosure of health information. They highlighted this especially in BetterHelp because the company was sharing email addresses to create lookalike audiences, but they only collected email address when you were providing your health history and signing up for telehealth services. So through that alone, you could infer that the individual had provided health information and had a mental health issue that they were seeking treatment for. So I think that's really where their focus has been in the decisions. I would say that all of your marketing practices should really get a relook and examination, because those were the marketing practices used by these two companies. But I think it's clear that any sort of third-party platform or digital marketing would be and could be the source of a new enforcement mechanism. And I'd say, like, finally, to your point here as well, really make sure that, as we talked about, your very well tailored and informative privacy policy matches all of the disclosures and language on your pub site. You want to make sure that you don't have any sort of conflicting language. You definitely don't want to indicate that you're not sharing data when you are sharing data, or that data would be anonymous. The FTC came down very strongly and has in the past. So again, not a surprise that just because data is hashed or you consider it to be anonymous doesn't mean that it actually is, and it often can and will be tied back to the individual. So to be clear and not oversell your amount of de-identification.
I think that all makes a lot of sense. And I'll just add that, you know, it kind of, you highlight the fact here, Kate, that, you know, US-based federal privacy law has always been very harms-based. You know, that you legislate, you know, for privacy where there's going to be harm to the consumer. And if they don't, you know, very often, if there isn't a harm, then you can't sue, or, you know, all these other things. So here, it's just wanted to call out that it's different from GDPR, where it would be, you know, you're just violating a right, not just, but you're violating a human right. And it's perceived, it doesn't matter whether or not the harm actually happens. You know, here in the US, it's definitely more, it makes sense that the FTC wanted to prevent harm to consumers in this way, given their mandate. And then the other thing I wanted to underscore was absolutely, if you're going to make claims, we could talk about them in terms of legal claims. You're going to make legal claims about the state of your, you know, personal data and it being, you know, safe and respecting privacy and all that. Then you're going to need to really demonstrate that, because you need assurances that are going to get, you know, make sure that your providers, your marketing providers, your partners, your downstream, your services that you're using are all in compliance with your privacy policy and whatever you're stating to the individual about how their data is going to be used. So every single time you have an interaction with the individual about their data is another, you know, it's another time that you're potentially making a promise that you really need to be able to back up that you're delivering on. And so being able to understand those data flows is essential. And then being able to have assurances where you can kind of easily prove that would be really helpful when working with regulators. And it's also garners trust with individuals. If you're able to be like, you know, if you press this button, this is what happens, right? You know, kind of to that effect, and have that understanding.
Yeah, I mean, like, it's kind of makes sense, because that's kind of the competitive advantage of the company as well. You know, hey, we respect your privacy, and, you know, this is what we're going to do. And if the company actually does that, then, you know, it makes sense, you know, more people kind of go to that platform and trust the platform with that data. So it's interesting how these, like, 2-3 things, I mean, which kind of make the entire ecosystem, you know, you have on one hand, you have to grow. So you have to, you know, the marketing activities for an e-commerce company, if applied similarly to a health tech company, can lead to some problems that you need to investigate. You are making promises which are super important for the users to trust on. And then, you know, finally is the regulatory aspect of it that you have to consider as you're growing and as you are building your products or doing marketing or targeting, right? With that,
I also just want to highlight that, like, it's not just healthcare and health tech companies. Geolocation data, age, race, sexual orientation, gender identity. I think the FTC is going to treat all of these things really aggressively. And so anytime you're collecting any data that's sensitive or could be used to harm the individual, it's important to remember some of these principles.
Yeah, no, thanks for that. In fact, I think it's a good segue into one of our posts. So what we're trying to just see is, like, what could eventually reveal the health information of a user. A couple of options. We'd love to get your opinion as well, Kate and Debra, on once the poll is towards completion. Okay, awesome. I'm going to end the poll now since we have a lot of answers. Okay, awesome. So yeah, I think pretty much screens, buttons, favorite items, they got 100%, which is awesome. Yeah, I mean, I think some of these things, Kate, Debra, if I remember correctly, are part of these finds as well. The name of the health mobile app being used. I mean, this is interesting. This is me being a product manager and thinking a couple of extreme edge use cases for sure. So yeah, I mean, I was thinking if someone is using an app, which the name of the app can reveal, maybe the sexual orientation or the mental health itself of the user, if that goes along with a identifier like a pixel or a cookie, definitely that would reveal a health app, right? I don't know what Kate, you or
I think
Debra
that's
think
the
about
point. Yeah, I mean, and it could be how the questions were written too, because it would depend on what data is. Like if you had a list of social security numbers and published a list of social security numbers, that's not even a HIPAA breach because there's nothing. It's just a list of numbers, right? You don't even know who they belong to or how to track that back. So typically you need at least 2 identifiers for there to be a challenge here. And so if you're collecting the name of a health app in combination with something else about the user, then definitely I think that would be considered, personal health. That would be considered sensitive data here. But if it's just the name of an app without the user, any other additional information about the user, not even the user's name, then you just have a list of a name of a health app, and that's not a problem at all. Use synthetic data to potentially, I don't know, if it depends on what it is that you're looking to find across your analytics. If it's awesome. Like, I want to see all the names of I want to see all of the health apps that our users use, for instance, and you're somehow able to do that in an anonymized way or in a way that, then that you tell the users that you're going to use it and you do it compliantly, then that very well wouldn't, be considered health information. So it really depends. It's contextual, just like all things privacy, it's based on context.
For sure. Awesome. And that brings us to the topic of,
yep.
I think like one of the most important things that I saw with all these enforcement or guidance is the definition of health data is broadened quite a bit. And Kate, like I think the slide itself is inspired from the content you shared on LinkedIn. So yeah, I would love if you can take and explain us, what is the new definition of health data and what are we really looking at?
Yeah, I think most companies are pretty well oriented in the back end product data and understand when and how they may collect health or sensitive information in their actual product. Many companies, I think, are still wading through the data that they collect through their public website, apps, and marketing initiatives to really understand what is or could be health data. And the FTC came out pretty clearly and indicated that if you collect an identifier, either through a cookie or other form of technology that includes a relationship to some sort of health content, that they are going to consider that health data. And health content is really, really broad. Everything from diseases, conditions, clickstream data, even in some certain circumstances, geolocation data, to the extent that you're located at a health treatment facility, as well as any sort of interaction with healthcare services, I would say. So consider that broadly in terms of either access or visitation to a pharmacy or products and services purchased online.
Yeah, maybe even the name of the mobile app for sure in some cases. Awesome. So yeah, quickly going into like some of the identifiers on, like obviously the online identifiers, cookies, pixels, IP address, these are some of them which could identify a user directly. There are always device IDs, right? So your mobile phones have a device ID, your Android ID, Apple has its own IDs, although, you can't really use them without consent. There could be account identifiers. Now, these are your own company's IDs, so some unique identifier that your company has assigned to a user. That potentially might not be a direct identifier, but if it's being combined with an online identifier or a device ID, then definitely there is a trail linking that account ID to a device ID and so on and so forth. Obviously, the names, the email address, they are also, directly identifying a user. I think what was interesting that came to my mind was the HHS guidance after the the pixel breach was if it's a health portal, if you are running a health portal after login, even a cookie is flowing to a third party, that itself is enough to, being called as health data. Is that what the guidance was, Kate, Debra?
Yeah, I think it was somewhat long established that any data collected after the point of login, so if you have a patient portal and logged into that, any data you collect via that patient portal, including some of these identifiers you've listed, would be considered PHI. What the HHS did through the guidance broadened that and said, even before you get to that portal, if you're on a university website or your doctor's website and searching for a condition or potential treatment, that also could be considered PHI if it's collected by or on behalf of a covered entity.
Awesome. And then this is I would say, some examples of health content. As Kate, you mentioned, Debra, you mentioned, this is, I mean, again, this could be like pretty wild or pretty kind of, it could go anywhere, right? So right from your screen views or page views, right? So let's assume you have a page URL where someone is searching a disease name, and that's going, I mean, by the way, that automatically, if you have Google Analytics, all screen names and page URLs automatically are going there. So if you are appending the search queries there, and if the disease name is going there, so that automatically, anyways, that data is being shared. So as I said, I've been a product manager very early on in my life. I've kind of made, not like basically done all these analytics. So I know how click data is flowing. So some of these are like taking me back to my time where, hey, someone signed up, we send that click data to saying, oh, success, failure, or someone abandoned the cart, right? But when we look at from a health perspective, all of these could reveal, right? So a successful therapist booking, if that successful event is going, to Kate's point, that itself, even before login becomes a PHI, right? For HIPAA entity, and for others, it still is revealing health data. Product usage data, I mean, this is a tricky one, right? We want to measure if our features are effective or not, but that again, the tricky part is these variables, these identifiers could actually reveal the health data very, very easily, because the way what you're trying to measure can reveal the health information. That's the whole point. Debra, Kate, any other data types or any examples that you find interesting that come to your mind that you would want to share?
No, I think what it was also highlighted as just another layer of fun here is that even if you've done the right things in terms of scrubbing some of the health data out of the information that's transited or collected to marketing providers, so you change your URLs to make sure that the URL didn't include any health related information. If your employees happen to disclose that information to an employee of the company, then that could also be considered a disclosure. So it's also, I think, a big part of these decisions was training and education and oversight of the marketing team to make sure that they understand how this could flow down to their day-to-day and didn't disclose information in a inappropriate or indirect manner with the third party as well.
I think that's a really great point. I think training is key. I think that's where we get a lot of the data leakage. It's just like a lack of understanding from engineers as they're, coding this stuff up. And it's not necessarily malicious, but it can get you in the same hot water. The other thing I'd like to say is something I've run into before is, where there have been legal contracts around the use of metadata, but metadata is defined from a legal perspective in terms of how, like internally, and in terms of like, this is what you can and cannot do with metadata, without a thought as to what that metadata might be. Is it PHI? Is it, PHR? Is it PII? Is it, it basically depends. It could be any different. It could be a whole host of things in that metadata. And so what I would urge companies to do is really flesh out based on data type, what, like in their contracts, what they mean, rather than just a broad thing like metadata, because you're not able to then put rules around it effectively if you're treating all of the data within this title of metadata as the same. So I think it's really important to be able to understand the data types, the purposes for collection, how it's being used, right? Obviously you have your ROPAs and all that, but at an engineering standpoint of understanding like the specifics so that you can put rules around it, basically, I think is really important.
Awesome. And I think we did touch about this, right? This kind of a bonus slide. It's not only about health data, but kind of, FTC is cares about all sensitive data. And to this, we do have a question as well. The question is about in terms of health FTC rules applying to institutions of higher education, where FERPA might prevail. For student health, what are we seeing? And I think it's Kate, it's kind of speaking to this slide as well. What's your perspective there?
I think higher education institutions will probably not be the focus of this type of enforcement. The FTC has been clear that they are tracking, media coverage and consumer complaints regarding health services in particular and telehealth services. So I think consumer applications in general continue to be the focus. That's not to say that FERPA and the education space doesn't have a ton going on of a different focus by both the agency as well as state AGs, but I don't think they're going to apply this case law to a higher education institution.
Thank you. Let's go ahead. Okay, awesome. So yeah, just to kind of we looked at the what really is health data, right? So that's one part of the puzzle, which is what data are you collecting, what data are you going to process in general. The other part is where that data could eventually go to, and that's the sharing part, which is leading to these fines and enforcements. And like basically, I've divided this into two big buckets. One is the tracker, that's the red zone. There are Google Ad Mob, Facebook ads, you have your pixels of social media platforms like LinkedIn, Snap, Twitter, TikTok, you have your data broker. So, kind of from a risk perspective, if you have these trackers on your website or your mobile app, you don't have control on how the health data gets used downstream. And B, what we've seen is this is pretty high risk from being considered as a health breach already, if you have these on your apps, right? The second part, which is kind of going beyond these trackers and pixel, is what other third parties could be on your platform, right? So one is analytics, right? You are running a company, so you will have some analytics vendors. The first category is Google's product. So there is Firebase, there's Google Analytics. I would say this is still very risky because at least what I've seen is that if any big companies like Google and Facebook, if you're using their product, you don't have any control on how they use data again. So that becomes as risky as, or maybe I would love Kate and Debra to talk about it. Is it as risky as a tracker or not?
My understanding. Oh, go ahead. Never mind. We'll get to it.
Go ahead, Debra.
I was going to say my understanding with Google Analytics is that you're not, so you get the analytics out of it, but in order to make it, either a free product or low cost or whatever, you're also giving data back to Google that feeds its ability to do all its, basically how they're able to kind of get all of their data in the first place is through Google Analytics, and kind of there's no good reason to send it to Google except to Google's benefit. So it's just by the nature of the product that it's doing a lot of this data collection. And there's some privacy, there's some analytics companies that are very privacy focused where you don't have to send data back to them. The whole point is for you to just, get the same kind of benefit as what Google provides without having to, have that data shared with them. And I just do want to also just throw out there, I think a lot of times people in marketing don't realize that the trackers and these third-party apps and analytics, they don't see it as like a sharing of data because of an individual's personal information. I think there's just more of a, no, this is just how we collect feedback on our stuff, but we're not like really sharing like their health information, right? And I think that we need to, a lot of that comes down to education, but a lot of it is like really training the marketing folks. Back to what Kate said, because this is all very much, you are sharing data, right? And it can, you can build insights by, if you're collecting data as a third party and you're getting it from all of these customers of yours that are sending that data, I mean, Google Analytics as an example, then you have a lot more opportunity to reach those people, to make profiles about them, to make assumptions about them, to push the right product in front of them, right? There's a lot that you can do or infer, and there could potentially be harms as a result of that. So anyway, I didn't mean to cut you off, so we'll go down the third party list.
No worries. Yeah, I mean, so definitely like this list again is not exhaustive, but like when you are thinking about what all third parties could be included in your websites or mobile apps. You have analytics. Again, like some of these products are by Google, some of them are not, like Segment, Amplitude. These are also pretty popular analytics platform. You have push notification, you have payment providers, right? And the risk I see as we looked at the definition of health data, right? All of these third parties will have some identifier going to them. And then if the health content we looked at, the definition is pretty broad, and that could reveal the health data. That could lead to a place where you are sharing health data accidentally or maybe, by purpose. And what would happen is like your disclosures on the privacy policy or the legal contracts might be insufficient. So that could be some of the risks that for the third parties, which are not trackers or third parties provided by really large companies, where the definition between the product or what they could use the data for is not really clear. At least I've seen that being part of some of these enforcements as well. Kate, do you have anything to add on this slide?
No, I think that's right. I think to Debra's point, analytics providers can get a little bit risky. I don't consider them as risky as ad tech providers, but Google hosts both products and there's a reason they do that. So I do encourage folks to take a look at their settings and make sure they've implemented restricted processing in all of the applications and services that they've implemented that offer it.
Awesome. So kind of re-looking at what all we discussed, right, and kind of trying to summarize, if you are running a health app company, what are the top risks from the enforcements and all the fines that have happened so far, right? So over to you, Kate and Debra, if you can talk about that as well.
I would just, I think to Debra's point earlier, just really do that data mapping with the marketing team, really understand what your service providers and vendors are, what data is going to them. Can they use that data for their own purposes? And is that accurately represented in your privacy policy? I think that a full marketing audit is probably well called for at this point.
Yeah, and then, again, so it's all about the data flows and understanding the data flows, but I also think it comes down to risk modeling, and risk modeling for privacy, you don't even have to do like a full-on, have like such a expertise in how to go about doing like full-on privacy risk modeling. I mean, just think about the unhappy path. Instead of thinking, let's build the app and here's all the wonderful things it's going to do, think about ways that it could be used to hurt someone, to malign someone, to the non-happy path, right? If it were abused, and start thinking with that hacker mindset of like, how could I make this, basically, how could I hack this, right? And how could I track someone? And if you go with that mindset, and you'll come up with some ways that you can then, find our vulnerabilities and then fix those vulnerabilities, and then you have a stronger app with better protections. And then you're able to even say, look, we've done our risk modeling, we've done a pen test, we've done all these things, right, to make sure that you're not going to have leakage. You won't have accidental, sharing if you've thought about ways at the points of data transfer and data sharing, and you've looked at all of them, right, you're less likely to have accidental sharing. And then the more automation you could put into your code review processes and stuff, along those lines. I know we're about to do a demo soon. Then I think the better off you'll be able to ensure that you're meeting your promises with and have those assurances, and then be able to display those assurances, as opposed to having mere privacy promises like we care about your privacy, and the same old tired things you see in a privacy policy that look like they're copied and pasted anyway, without real thought being put into a particular organization's like flow of data. So I think there's a lot you could do if you take some of these proactive actions to really make your product stand out and be trusted.
It makes sense. I think one last point that I think Kate or Debra, I think both of you mentioned, is a lot of these tools do some level of data collection automatically. They have settings, so having that list and then having a more privacy friendly setting would be super important. And kind of like now jumping into, we looked at, the risks, what the regulation says, what all is health data and the third party ecosystem. Now, if you have to go back and kind of see how you can, prevent this from happening, or how you can start auditing, I would say like 3 broad steps. First is kind of what Kate and Debra both said about data mapping, discovery, right? So going back, for your product team, so all the mobile apps and websites, for your marketing team, figuring out what all data types you have, including specifically any health content data. It'll be tricky, but that's kind of important. Second is discovering any third parties which are there, right? So it could be via an SDK, it could be via an API, it could be via pixels, it could be via another platform that your marketing team is using that you're not aware of, right? So building that third party inventory is super important. And finally, discovering all the data flows. So once you do that, and once you have that understanding of what's your data, where it could potentially go, and what is the current data flow story, that's when you know from a risk perspective, hey, this is what we have, right? And remediation wise, it's super important. I would say, like, as you have data minimization, especially if you have mobile apps which are processing health data, removing these unnecessary third parties would be the best first step. Obviously, you can't eliminate all of them, but then looking at the data flow and saying, hey, do we really need to share this specific data element with this third party, or does it only need some specific part of the data? So looking at the data flow and saying, hey, do we really need this health data being shared with a specific third party becomes important. And once kind of you've done that, then as Kate mentioned, the privacy policy has to be like, super clear in terms of what data, health data you're collecting, who you're sharing it with, so that, the reality matches, what you have in the product, what you have in the marketing team, right? Also, probably like having some contractual guarantees with your third parties on how they will eventually use the data that you're sharing with would be important. And yeah, finally, so this basically takes you to a place where you have discovered what's happening and kind of fixed the thing. So you find the issues, you fix the issues, but the most trickier one is your business is not going to be static, you will grow, and you will build more products, you'll add more features, your marketing team will grow. So you definitely want to be in a place where you want to start preventing it. We've seen that happening on the security side. It'll be important to kind of take your privacy policy, health policy, and making it part of your software development lifecycle. So it becomes part of the continuous CI/CD code check. So if a new third party is deployed, it basically goes through the approval flow. If a new health data flow comes in, that should actually prevent the product from going live. And basically, this embedding privacy in this software development lifecycle and CI/CD essentially will make it continuous. Your assurance is continuous. You have auditability, and that basically ensures you can prevent these issues from happening. So discover, remediate, and prevent. If you kind of look at it from this perspective, you can be in a really good place. And with that, I know we have 10 minutes left. I'll take a couple of minutes and quickly show how Privado can help you achieve that. Awesome. So yeah, as I talked about, from a prevention or a compliance perspective, what you want to do is discover, fix, and then prevent. So I'm going to focus on the discovery aspect of it. So what I've done is we have an example of a leaky health app. It's processing a lot of health data, but also leaking that data to some third parties. And typically, this is how we discuss. There is some health content which was along with identifier going to some third party. So this is kind of a real life scenario based on inspiration. And so what we see here, for example, is this health app has a couple of data elements. So gender, device ID, so these are identifiers. And there is a health data element called illness or medical condition, which is being shared along with email address and others. So what you are interested in from an audit perspective, and this is what Privado brings to the table, is we'll scan your mobile app, we'll scan your website, basically anything your engineers have developed or a product team have developed, and give you this visibility on what's the data type. And then we go deep in and figure out any health content data as well. And then second is what's the flow of that data type, where the data is eventually going to go in. And a combination of these two will help you again discover and remediate all the issues which are there in your product. So I'm going to take an example of illness or medical condition, and this is being shared with three third parties here: Facebook, Firebase, and Google AdMob. And now what you can do is you can also do like a reverse view and say, okay, I'm interested in AdMob or Facebook AdMob because that's the ad product or the pixel product. And here, email address, illness or medical condition, and gender, all three are going along with some tokens. And that's basically exactly the reasons why the fine was there, right? So you were sharing health data with a third party, right? The interesting things is how Privado detects this illness or medical condition. So I'm going to go into the code. This is, when you move to the second part of fixing it, this is the example you want to share with your engineers that Privado enables. So helping you bridge the gap between from a policy and an engineering perspective, right? So So for example, this is the flow to Facebook. It starts with because there is something called purchase coupon, which was basically revealing that you purchased like a health product or a drug product. And that was essentially, again, kind of health content data, which was flowing very nicely from here to the last step, which is Facebook's SDK, right? So that's one example where, we tagged something which was health data. It was not really like direct, but it was kind of a health content data. Similarly, for Google Firebase, again, this is another property. If a user used a health coupon or a coupon for purchasing health, again, that was flowing. So that's another example of something which can reveal health information. So again, like Privado goes and kind of discovers in the first step these data types, and specifically for the health use case extension of that, including findings, all the type of health content data, and then find the flows, help you fix it, right? That's about it. And then, yeah, we open up some issues, help you clean it, and then we become a part of your regular software development lifecycle. So tomorrow when your product changes, and if you suddenly introduce a new third party or a new data flow, you can catch it before it hits production. And you don't have to rely on people to tell you that. Basically, the product tells you, it notifies you on Slack or email saying, hey, we have a new third party. Let's make that compliant before the product goes live. With that, we are on the last section, which is Q&A. So feel free to ask any questions. And as we are kind of looking at the questions, thanks, Kate. Thanks, Debra, a lot for, I learned a lot while preparing for the webinar and kind of how you were explaining things. So that was super helpful.
Excellent. Excellent. Well, I'm glad to be here today.
Absolutely.
And, I'm glad you put this together, and especially, to be here with Kate.
Yeah, there are a couple of comments and yeah, some of the questions. So thanks, Phil. Thanks, Aima. Yes, Rahul, we will circulate the recording later. And then there's a question about Privado comparison with OneTrust and TrustArt. Yeah, I think I'll take that up. Basically, Privado essentially focuses on, it takes more of an automated approach. What we are really doing is we looked at the gap from a product and engineering perspective, and nobody really has an automated solution there in terms of what's really happening there. What Privado does, essentially it goes in and scans all the products and applications that your product team, data analytics team, data engineering teams are building, and then give you the visibility on what's happening with data. So basically answering the question of what data do I have and where does that data live? The $1 million question of starting a privacy program is that, and we basically cut that entire process short from months to basically a couple of days. So that's basically the main difference. We bridge this privacy engineering gap by automatically scanning all your products and applications. Awesome. I think we are at the end of the webinar. Again, thanks everyone for joining in and spending time with us. Thanks again, Kate and Debra, for your time and helping us think through what's happening on the health side. And yeah, talk to everyone soon.